Good morning. My name is Ed Davis. I'm with Sequor Law. This is the first time in an actual conference I'm able to introduce myself as Ed Davis of Sequor Law, because some of you know that for the past 15 years or so I've been here as a partner at Estigaraga Davis. So this is our new firm, and I'm thrilled to be here in that capacity. I'll be chairing or moderating the panel today on Till Divorce Do Us Part, Recovering Assets Concealed by High Net Worth Spouses. We very much want to have an interactive session, so if you have a question, we're prepared to take them as we go along. One thing I will ask is that we do not want to answer questions about specific cases. We're not here to answer questions about a case that specifically. Issues are important, but if you have an issue about a specific case, we'll talk about that afterwards. We're happy. We'll make ourselves available all day if necessary to do that, so that you have us. But we want to make sure that we keep the seminar on and the panel on track. And we understand this is a particularly emotional topic for a lot of people, myself included. So we want to very much, though, stay on issues and how we can both spot and solve issues in these very difficult cases. Let me introduce my co-panelists. To my left is Metta MacMillan-Hughes, who's a litigation partner with Lennox, Paton, or Paton, pronounced properly, LXP, as some of us call it, in the Bahamas. She has over 30 years experience in litigation involving asset recovery and discovery in cross-border insolvencies and international litigation. She is the only fellow of the International Academy of Matrimonial Lawyers in the Bahamas and regularly represents one or other party in high net worth family law disputes and divorces. She is a member of the English and Bahamas bars. To my right is Zach Potter, who is a partner at the matrimonial firm of Fisher, Bendeck, and Potter. Zach's practice is limited to very high net worth clientele. They only take 3 to 4 clients at a time. Generally, people find Zach and his partners when they are in trouble. Kind of trouble where you wake up one day and your husband tells you that he wants a divorce, and even though you thought you were worth hundreds of millions of dollars, there's nothing left. Zach is one of the 2 lawyers whose work was recently profiled in the New York Times Magazine in the article entitled How to Hide $400 Million. The editor of Town & Country magazine called it the story that everyone is talking about. That is true. Everyone in my firm has read that story. It is rare for a story about asset recovery to capture the public's attention, but this one did. Zach is a graduate of Princeton University and Yale Law School and is here to give us his perspective on how matrimonial law can be best used in large asset recovery cases. So I thought what we would do first is, before we get into the meat of our topics, and we've got 6 subtopics that we want to talk about, we're going to try to limit each of those subtopics to somewhere between 10 to 15 minutes and then leave time for questions, is that I would sort of walk you through a few of the issues that we see in these cases on a regular basis. I do, lest I forget and lest I'm remiss, I want to thank David and the organizers of OffshoreAlert for inviting us to have this panel. We've been wanting to have this panel for a while, and it's great that he did. I also want to thank, although she's not here right now, she's on her way here, Niana Miller, on behalf of the whole panel, who did a great job pulling this panel together with us. She's a lawyer in my firm, and she works on these kinds of cases with us, as well as John Silberman, a lawyer with my firm, who's also helped us in the background. So thank you both for that. So these kinds of asset recovery cases are not the normal asset recovery case. Many of the same attributes of asset recovery are here, but we are dealing, as I said earlier, with a very emotional, tough issue. So I want to talk about some of the things that we deal with in these cases that we don't necessarily deal with to the same degree. One thing that is very similar, and this is where I think we have to convince the court that we are dealing with a victim of trauma. A person, and in our case, it's always the wife. We've never represented the husband, because we've yet to get, I guess, to a point in our society where the wife has made all the money or taken all the money. Maybe women have an innate sense of fairness and haven't done that. I'm sure there's a case out there. We haven't seen it. There is one. Oh, Metta says there is one. I guess that's some bizarre, perverse measure of progress, that there are women that have taken the money offshore. But so I'm typically going to talk about the wives, because that's inevitably, or almost always, 99% of the time, the victims. And these These victims are no different than any other fraud victim, any other trauma victim. And one of the things that we always deal with in our practice is how do we deal with this process they have to go through. So typically there's a denial phase with every victim of fraud, whether you're a Ponzi scheme victim or as we just read from Zach's case, where you wake up one day and you think you're part of a family where you have hundreds of millions of dollars that you helped earn and they're all gone. You first go through the phase of denial, and there's a lot of that. And you know, one of the things I want to mention is that it is possible for a client to get stuck and never get out of any one of these phases. The next phase we tend to see is the anger phase. It is impossible to make good, solid, rational decisions when you're in the denial or the anger phase. You just can't do it. It's impossible. So as lawyers, we're trying to get our clients through those phases as quickly as we can. The next phase you tend to see is the sort of bargaining or self-blame phase. And this is where victims can be quite vulnerable to what is called reloading. Reloaders are people that double down on the fraud. So in this case, the reloader would be the husband, or the husband's agent, or the husband's a close family friend who's putting themselves forward to try to solve the problem or help you. Those reloaders are typically trying to, and they're going to get you to sign something or agree to something that is definitely not, or your client, definitely not in their best interest, but it's at that moment when you are the most vulnerable that many times you'll have situations evolve, or even be some sort of, what is the word I'm looking for, where the marriage is, where he takes you back, if you will, or you take him back. Again, because they're trying to get their ducks in a row, because they ultimately want to steal the money in a way that is as difficult as possible for you to get it back. There's then a depression, typically a depression phase, where, you know, it's very, again, I've had clients literally disappear off of they don't call you for 2 months. They're just completely wiped out, they're gone, we can't find them, we're in the middle of litigation, and we're trying to get decisions made, and I'm not laughing at all, I'm just saying it's frustrating, and you know, our reputation's on the line with the court, and our client is going through a very, very difficult emotional phase. And then we get to acceptance, and this is where we try to get all of our clients to. We try to get them through this process as quickly as we can so that we can make intelligent, rational decisions and put fire on target. And that's one of the things, and I know that both of my colleagues, before I move off of this, I just want to open it up for just a brief moment for either of you to comment on this, because I want to be clear, I'm an asset recovery lawyer. I don't get involved until matrimonial lawyers like Metta or Zach bring me into the case, because we don't do matrimonial law. So some of these phases I don't actually live through in the divorce case. I do in a regular fraud case. So the asset, hopefully by the time they come to me, the client is already in the acceptance phase. Anything you'd like to add?
Well, I had an experience where I had got an order against the husband for committal to prison. He appealed his committal. He went, there was an appeal date before the Court of Appeal. There was a stay of the committal proceeding to prison, and I arrived at the Court of Appeal ready to go in, and big surprise, there was my client sitting next to the husband's lawyer, who was grinning like a Cheshire cat, and the client he says to me, "Your client has something to tell you." So off we go, and she says, "I don't want to proceed with the committal to prison. We've made a settlement." Well, so they'd got to my client, and that was a short-lived experience. He was involved in drugs. She took him to a drug rehabilitation centre. On the way there, she stopped to get directions at a gas station. When she got back into the car, he slit her throat from one side to the other. I mean, these are the sort of things that happen, and you have to consider in all matrimonial cases. He did go back to prison in the end, and he did pay his dues. But those are the sort of issues that you have to deal with
Yeah, well, let me just say that the women here, and I'm going to ask you to specifically comment on this, Zach. The women in these cases are victims of sometimes physical, certainly psychological, emotional, and financial abuse. You have to think of them in that way as you take this client in, and understand that you're going to have to provide for that kind of support. Zach, how do you deal with that in your firm?
Well, so I'll address that, but one point that I wanted to make on your stages of grief that's been sort of an interesting aspect of dealing with this type of case is I've learned that, and I'll go with the husband and wife instead of the moneyed or non-moneyed spouse for the same reasons as you, although we had a case where it was inverse. But these stages, I'll call it, the husband or the fraudster or the person who has stolen the money and hidden it, he needs to go through these as well, but it's not about the loss of the money, it's about the loss of control that's going to happen, the loss of control of the marital relationship. And so what you find is in the beginning stages of these cases, frequently, you can't get anywhere on a reasonable settlement discussion because the person who has hidden the assets hasn't gone through these stages yet. He'll be at the denial stage where he believes that he can still exercise complete and total control over the relationship, frequently as he has for years and years and years. And so if you come in and you say, well, this sort of thing is easy, it's a 50-50 division, we have a fairly good sense of what the size of the marital estate is, let's just sit down and work it out. The answer is going to be no. She's going to get zero, or she's going to get some equivalent of zero, and she will take what I offer. And we sort of have an internal word for our sort of way of describing this, which is that the court needs to bloody his nose a few times for him to go, to get out of the denial stage. Then there will be the anger stage, then some sort of nonsense bargaining, perhaps depression, and then eventually acceptance. But the court needs to bring that person from the first stage to the final stage through, some very tough orders, the type of tough orders that judges are frequently uncomfortable entering and won't do without the right record. But
it's a really, really good perspective that we are dealing with two parties, and you've got to get both of them through that emotional thicket that they're both in, regardless of the respective merit of it. They have to get through it, right, one way or the other.
Yeah, you have to deal with the psychology of the abuser and the abused. And now, from the perspective of the abused, one of the difficult aspects of this is if they've had their lives completely controlled by somebody for years and years, and that person is, essentially the master of their world, in the sense that he created the wealth and he's been controlling her life, and then he says to her, you will never find all of the money. You're not going to get anything, and you'll never find it, and essentially I'm going to make a fool out of you in this process. And the difficulty that creates for somebody representing...
Every case, by the way, every case.
Every case, yeah. Every case like this, these unique cases. And so an analogy I have for it would be similar to if you told your children, there's going to be an Easter egg hunt, and you will never find all of the Easter eggs. And when do you stop looking, right? And it's a huge problem in our cases because first there's the assets I would call hidden in plain sight. And fine, you do what you do with respect to them, but the really difficult part is when you are now looking for the Easter eggs that are not hidden in plain sight. And at some point, you need to convince your client or have a discussion with your client that we probably have found 99% of the Easter eggs, or 98%, or even 100%, or even 110%. I mean, there's ways that you've actually discovered more than there is. But your client has been told by somebody who has controlled her life for a very long time and who's been incredibly successful in his endeavors that you will never find it. So what happens is we have a moving goalpost problem. so that everything that you find is an indicator that there are still yet more Easter eggs out there. And if that is the psychology, each one you find shows there's more out there, then you can never get to the end of the process. And so one of the most difficult aspects of these cases, particularly when the other side continues to lie. So let's say you have a financial affidavit that's still on file that says the person is broke. You know they're not broke. And they're not willing to come to the table and sort of what we call like open the kimono and say, this is where I hid everything and so on. When they're not willing to do that, it's almost, it can be incredibly difficult to bring the case to closure, because the psychology of continuing to look, continuing the game, and the belief that maybe that next Easter egg is the most valuable one that you never found.
One way we deal with that in a typical fraud case, and we do 12 different strands of asset recovery. Matrimonial is just one of the strands, is that we like to sit down with a client very early in the process and say, we put on the whiteboard, define win. And we ask them to tell us what they would think a win would be. Now, if the circumstances meaningfully change along the way, everyone's free to change the definition of win. But it's very difficult as a lawyer to design a strategy when the goal is a moving target. And so we try to get our clients to buy into that and understand that our job is to get them as close as we can to the life they want, either as a fraud victim or as a matrimonial fraud victim. We're never going to get them necessarily all the way back, and we're never going to get them revenge or vindication. The legal system is not built to get you revenge or vindication. It can't do it. Judges aren't interested in giving it to you. They don't have the time to give it to you, and it's like cotton candy. You put it in your mouth and it's gone that fast. There's never any substance to it. So really it's about trying to get them there. So I want to move on to our first substantive topic. I thought it was
before we move on, can I just make one more point from the matrimonial perspective? One of the difficult things about having that conversation at the beginning of our cases is if you're dealing with somebody who's a liar, then many times it's not just their wife they've lied to, it's the banks and other people. And so if you have that conversation at the beginning, you might actually find out that, that when they have been telling the world they're worth $1 billion, they've been lying to everybody. And so if your client believes they're worth $1 billion, but they're really worth $100 million, and you set those goals in the beginning, you have to recover $500 million in a case where there's only $100 million, it's not going to happen. And, it's not going to settle at $100 million either,
Yeah.
Because that's,
even though that's actually a complete slam dunk win.
You're right, exactly. So that's a difficulty.
And the other side of that scenario is that the husband will be pushing forward in the divorce proceedings to move the financial provision applications forward and on, and the wife will be saying, but you haven't disclosed this, you haven't disclosed that and the other, but at a certain point the court is going to actually step in and say, set some deadlines for final disclosure and all the rest of it, and move forward. So it's not entirely, certainly in the Bahamas and in England, it's not entirely in the control of the wife and her lawyers to keep this investigation going on, and the court will step in and cut it off at some point.
One substantive law point about this is, so what we're describing here is, a violation of trust. You have the marital estate, one side, takes it, steals it all, hides it. But there's a case in Florida called Beer v. Beer, which stands for the proposition essentially that in a marital relationship, the parties don't stand as sort of financial fiduciaries with respect to each other. It makes sense for the normal marriage. So, you're married to somebody and he or she makes bad investments in the stock market, things that they shouldn't have done. They put all, they didn't diversify. They, bought penny stocks. They lose everything. And, for the average case, the court's going to say tough luck. I mean, that's the person you married, and they poorly manage the finances. Welcome to the real world. What we have found in our cases, and I don't know how many practicing lawyers are in the audience, but is that you can, in cases like the ones that we're describing, you can plead around beer v. beer. And if you look at it, if you look at that case closely, if you include the right types of allegations, which in a case like this, it would be something like, you know, the wife was, you know, prohibited from seeing bank records. She was prohibited from having any role whatsoever in the finances. She was promised that, you know, that these things were being done for their mutual benefit. I mean, you can think of what the allegations are, but you can plead around that case, and if you plead around that case, it opens up some, you know, some avenues for relief for your client.
I think, you know, the other part of the frustration that fuels the beginning part of the case, and we're going to move now into tracing and trapping of assets, is that it's not as if the wife wasn't at the house or on the yacht or at the vacation home. She was there. She lived it. And then the husband literally will stand up and say, there's no house, there's no yacht, or I sold it, or it was leased, I never had it. And so it's a complete lie. And the frustration level that we have to deal with, at least on that side of the equation, is quite high. So again, it's about staying on target. So really, the interesting thing about matrimonial cases is that in a typical fraud case, the way our firm approaches them, if you're waiting to get a judgment, you've already lost. You can't win a case on a judgment. If you're waiting in a fraud case, you're going to be years down the road, and you've got to do things to freeze assets and steal the other person's war chest and take the assets and lock them down at least while you litigate about entitlement. But in a matrimonial case, and we'll come on to some of the ethical issues we face in these areas, in this area, there's really a dichotomy in the case. There's the pre-judgment phase, and there's the post-judgment phase. Most asset recovery lawyers, true asset recovery lawyers, are not going to get involved in the case until post-judgment. And this is a challenge we face, and one that so I'm going to put it to my two colleagues to tell you a little bit about what they do pre-judgment and what they can do, and it's very different in the Bahamas than it necessarily is in the United States. And then how do we get to post-judgment phase as quickly as possible, because this conference is called OffshoreAlert, and we're talking about the offshore piece, and there's these high net worth cases always involve major offshore assets. So let's start with you, Metta, and talk about a little bit about what tools you have and weapons or tools in your toolbox with regard to the pre-judgment phase, and then how do you lead it over to the post-judgment phase?
Well, certainly in the Bahamas and in England, as soon as you commence divorce proceedings and you pray for the ancillary relief, the husband is then bound to make disclosure. And then that is when you're going to look at that disclosure and find that it's deficient, and you will then get orders on directions for further disclosure. In the meantime, what you do is you get an injunction, and that can either be based on the fact that he is dissipating assets, and you have evidence of serious risk of dissipation, or it can be on the basis that you need to preserve the assets pending the outcome of the ancillary relief proceedings. Certainly in aid of the Morava injunction or the freezing order, you will get an order for disclosure of assets. So, for example, in the Bahamas, if you have a case where they're foreigners, but they're permanent residents of the Bahamas, but they'll have all their assets offshore. What you're doing is you are getting the order against the person. You're not getting the order against the third parties. So their investment bankers will receive notice of the order that's been made against them, and part and parcel of that order can be that he signs a letter instructing them not to act on his instructions and not to release the assets until there's an order of the Bahamian court authorizing that to happen. And you will make, in the context of that order, you would make a provision for living expenses and legal expenses and so forth. And you would then get a full disclosure, according to him, of his assets, of his tax returns, and so forth, on pain of committal to prison if he doesn't comply. I mean, that's one of the best avenues to go down, because it's amazing when it gets to, you know, the 11th hour, what's forthcoming. And it also gives you an opportunity on the committal proceedings to cross-examine the husband. So you're cross-examining him at a very early stage in the proceedings, and to call evidence, to subpoena other people that can give evidence as to the assets. For example, wealthy husband fails to give full and frank disclosure in aid of the Moravian injunction. Committal proceedings started. Cross-examine him as to the home, the massive home that he is occupying in a very wealthy area. Response, oh, it's leased. From whom? From a company. Well, who is that? Who owns that company? How did it? I don't know. You're not. So you're not the beneficial owner of that company, no. And I know, you know, your car is held in the name of a company. So they feign, no, you know, that they have no knowledge. And then what you do is you adjourn their cross-examination, and then you call other witnesses. For example, I did in one case, Director of Immigration. Director of Immigration, bring your file on this man and everything that he submitted in support of his permanent residence application. Permanent residence application, you need you know, to set out all your finances and your wealth and the nature of your investment in the Bahamas.
And they're going to tell the truth there because they want to get in. They're going to say everything.
Yes, and so then everything is brought to the fore. So this company that he said he didn't know anything about, you know, Mr. So-and-so, would you please tell the court the basis upon which you know, what the financial disclosure upon which you relied, and is there any mention of a company? Yes, there is. What do you have in regard to the company? Well, I have the, you know, the annual returns, the shareholdings, and is Mr. So-and-so mentioned in that? Yes, he is described as the, you know, the beneficial owner of the company. So meanwhile, this guy is, you know, he's falling and he's listening to this. So that can promote a settlement. If it doesn't promote a settlement, then he'll end up in prison. If you've got a judge who is a no-nonsense judge, in that particular case, we actually had an Australian judge who was no-nonsense, and he went to prison for 6 weeks.
I know that judge. I was in front of him. He's quite tough. So Zach, let's turn it over to you. I do think that as we go through this process, one of the issues we have to confront is, you know, the lies and how you deal with the lies. And sometimes lying is helpful because you're setting them up. They're going to lie anyway. So at least get them locked into a solid lie they cannot wiggle out of later, so that when you do prove the opposite, you've got them with a bullseye painted right on their forehead.
Yeah. Well, you know, the lies are the best part of the case. It's what you want, right? You want them to lie to your face, because the way that, you know, the way that I describe these frauds as working is they're intended to make getting to final resolution happen on the 9th of never, right? So, you know, if you have to bring in these entities, and then you're fighting jurisdictional, but you have personal jurisdiction, and you're briefing it up and doing discovery on jurisdiction, it goes on forever and ever and ever. So what you want is a way to skip over that entire process. And the way that you can do that, that we've found success in, is through, you know, things like, you know, the remedies that are available when somebody commits a fraud on the court. So if you get a big, bold-faced lie or a falsified document, and they exist, you know, the lies exist, obviously, in these cases, but the falsified documents exist as well. And once you have that, you can skip to the end because the remedies for doing that sort of thing are relatively clear. So
what are they typically? Like in the prejudgment phase, what weapons do you have that we can use? Again, it's asset recovery, and I imagine, Zach, that on the onshore piece, it's a little easier than the offshore. In the offshore, you kind of hit a little bit of a brick wall from the U.S. perspective.
I suppose. Well, I mean, that depends. That's complicated, but I mean, you're looking for the traditional remedies that exist, which are, for example, prohibiting somebody from denying, certain information and so on. And in a divorce case, it can be incredibly powerful. Let's say that you have some sort of net worth statement that says somebody is worth X. In our earlier example, we said that they had previously said they were worth $1 billion, but in reality, they're worth $100 million. Now, you've proven that they've committed a fraud on the court. Let's say they violated discovery orders, and so on. You can, in that instance, you can very credibly move for an order to prohibit them from denying that the marital net worth is $1 billion. In which case, you are now dividing up in excess of what actually exists, and it's a disaster for the person who thought that this fraud was going to help them in their divorce. It's going to allow them to settle for less, when instead they're going to be looking to get out of the case for some very high percentage of their assets, if you're able to, as you said, lock them down so that they can't access them either. And there's ways to do that even when they're offshore, as you mentioned. But now let me just speak a little bit about, that's just sort of anecdotal stuff, but the pre-judgment versus post-judgment. In Florida, there's a statute 6111, and it was originally drafted in a way that allowed for pre-judgment injunctions to secure support, alimony and child support. And you can get, a writ of naexia. You can get people's passport.
For those that don't know, what is a writ of naexia?
It basically, is incarceration order, or
takes your passport away.
Takes your passport. You can do that. And 6111 is powerful in a matrimonial case because it's available pre-judgment upon showing of dissipation. Now, what's interesting is that even though the statute, if you just sat down and read the statute, you would think that it was only available to secure support. And in a big case, in the big cases that we're talking about, there's enough money usually to pay support, so you wouldn't think that it would apply. But it's been judicially construed through a number of cases, like one that off the top of my head is called Sandstrom, to allow it to be applied in the context of securing equitable distribution. And now that's an incredibly powerful thing, because if you're representing somebody, a wife with a inchoate claim at this point, you can still get an injunction to secure the marital estate because you're securing the equitable distribution. And so my experience in obtaining injunctions is that it's much easier in the pre-judgment context because of how 6111 has been construed. This is all somewhat gray area stuff, but it's pretty clear in the pre-judgment context that you can get it. Then when you move to the post-judgment context, let's say you have a judgment for $30 million, getting a 6111 injunction to secure that money is far more difficult. I'm not sure that you can. Again, this is all gray area stuff, but your remedies are more powerful because of this judicial construction of the statute in the pre-judgment context, in my experience.
I think one of the keys in asset recovery is getting somebody on the inside to flip. In a divorce case, you kind of have the ultimate insider. You'll have, to the extent that the wife has been involved in the family business, or has been involved, she owns bank accounts with her husband, she owns real estate with her husband, or she's at least aware of it, you'll have someone who's can flip, essentially, and give you the inside look on what's going on. So you have visibility into what the fraudster was doing. And if I could literally reach out and say to every woman who's contemplating in a high net worth divorce, or any divorce, frankly, contemplating filing a divorce, is to prepare for that as if you were preparing to take your family to Europe. That same woman would do meticulous planning, They would lay everything out. They would think it through. Obviously, they're not in an emotional state when they're preparing to take their family to Europe. But that preparation is so critical. And I'll give you an example, an actual live story that a case we litigated. Our client was in Palm Beach, traditional wealthy family. Lawyer was a disbarred lawyer, manic depressive. It's amazing how many manic depressives we see in these cases because they're brilliant. I mean, many times people who are manic depressive border on brilliance. They're super smart people. And this particular guy had gotten disbarred for bad conduct as a lawyer, but he became a day trader. And he basically lived in his house, except for 2 days a year he would go see his mother. Well, he didn't sleep much when he was in his manic phase, and one night the client saw him digging around in their garden in the middle of the house. The house was one of these big square houses with a garden in the middle, and he was digging in the middle of the garden. She thought, that's odd. Why is my husband digging in the garden? So she waited. Husband went a couple days later to New York to visit his mom in his annual pilgrimage to see his mom, and she went and dug around in the garden, and clink, her shovel hit a metal box. She dug the metal box up. She pulled it out. She opened it and realized she had bank accounts in Liechtenstein, foundations, all kinds of information about stuff she never knew about. Even though she was the insider, even though she was the wife, she had no idea that this guy had all of this stuff offshore. So she went to Kinko's, she photocopied everything, she put it back in the box in exactly the same order, she reburied it, and didn't tell him about it because she was still on the fence. She loved him. She was still on the fence about whether she was going to get divorced. She was trying to help him through his medical issues. She was a nurse, so she had a very strong reason to want empathy with him. But ultimately, it became to the point where she had to file for divorce. So what do you think husband did in the first hearing? He lied through his teeth. And so obviously, the lawyer had been, he's now deceased, the lawyer. I would love to have him here to tell you, because that's the cross-examination that you dream of as a lawyer. And literally went through each one of these assets. Now, tell me about the assets you have in Liechtenstein. I don't know what you're talking about. I don't even know where that is. Never heard of Liechtenstein. Okay, thank you. You sure about that? Yeah, absolutely. You could see and then of course, he said, well, interesting. Would you tell me about this account then? And after pummeling him like that, the judge broke for lunch. And when he broke for lunch, the lawyer who represented him was a well-known lawyer, and Zach knows him in Palm Beach. They went to lunch somehow, and they came back from lunch, and they're sitting around, and the judge calls. The judge comes in. He's like, everyone here? The bailiff comes out, and they're like, no, my client's not here yet. An hour goes by. The judge comes out and he goes, what's going on? Where is your client? The lawyer said, I don't know. He's calling him. The guy went home, packed his suitcase, got in a flight, and fled. He's gone. And we ultimately traced him to Hungary, then to Israel, then to San Diego, believe it or not, where he ultimately ended up with a woman who looked amazingly like our client and who was also a nurse, interestingly. And we had gotten her money in other ways about using assets internally in the United States, but essentially at that point we were asked to discontinue the case by the client. And the client said, look, I've been threatened. I believe it. He's going to kill me. And therefore I want you to I got enough to live comfortably for the rest of my life. I don't want to be dead. Plus he has to be himself for the rest of his life. That's punishment enough. And so she dropped the case. But it gives you an idea of some of the preparation. If you have the preparation, that's a bad ending but the preparation is the key. Getting all that information, if you have access, you ultimately have the ultimate, you have the insider. Have you guys had instances like that where that kind of evidence is fallen into your hands from a client?
There's almost always some of that. Because over the course of the marriage, somebody is found, taking pictures of some financial state. There's always a metal box in the garden to a certain extent. But from a practice tip in this type of case, we have a perspective, which is that the metal box in the garden is the privilege log. And we fight privilege claims at a level that frankly horrifies our opposing counsel. And the privilege log is where the bodies are buried in these cases frequently, because many of these types of frauds can't be done without the help of professionals. And then those professionals that orchestrated it work with the litigation counsel. I'm not suggesting any improprieties on the part of litigation counsel, but they do. They need to work with the people, behind who are running let's say these, shell entities and things like that. And so what happens is the privilege log gets filled with communications by and among the individuals who are involved. And from our point of view, and we're, every decision that we get on this, we're publishing on Westlaw all of our trial court decisions, because we want the law in Florida to develop in this area. And we're getting more and more orders out of the trial courts overruling privilege claims in this area, and not only overruling the original privilege claims with
so for the non-lawyers, there are some here. Just for 2 seconds, explain how privilege works.
Well, communications between the client and the attorney are protected and not subject to disclosure in the case. And
not just the divorce lawyer, but even maybe the lawyers that helped husbands set up some of these structures.
Yeah, absolutely. And so the reason why, and I recognize that there are, individuals at this conference that, do asset protection, planning, and so on. And so we're talking. We have all your cards. We know yeah. We're talking about instances in which, a fraud has occurred. So I do want to limit my comments to that. But, frequently in situations where somebody wants to commit a fraud, they utilize the help of a lawyer, because that will allow a privilege claim to be made to protect those communications from disclosure. So you don't want to just hire a business manager to set this sort of thing up, because then any emails or documents in the file are going to be subject to disclosure. But if that person can put on the hat of being an attorney, now it's going to be a fight, very difficult fight to get access to that file. It's going to take, sometimes it takes years.
Or you never get there, because some judges don't have the gumption, frankly, to allow you to use the crime fraud exception to get beyond the attorney-client or accountant-client privilege.
Correct. And the way that Florida has interpreted, there's a process for getting a ruling on the crime fraud exception to the attorney-client privilege. Basically, what the rule of law is that if attorney or an accountant has been consulted in order to commit a fraud, then that is not something that's protected by privilege. So by the way, the attorney doesn't need to know that they're assisting with a fraud, which is sort of an interesting aspect of this. So if I went to somebody and I knew I had a giant creditor, and I didn't tell my attorney, and I asked them to move all my assets into a some sort of offshore trust, you can break through the privilege even though the person who did the planning didn't know they were helping with the fraud.
But it's one thing to say that as a lawyer, I didn't ask my client if he had some big claim against him. But you can ask if he's married. You would think, you'd say, oh, are you married? Do you have kids? And normal human interaction when you're meeting your client. I mean, if you're sitting there as a lawyer or as a corporate formation agent or any professional, and the person's asking you to transfer gobs of assets offshore, and you know they're married, I'm sorry, there's a special place in hell for you.
Yeah. But here's the thing about the crime fraud exception is it's actually not what we find ourselves winning on the most. It's not that we lose on that issue. It's just that the courts of appeal have set up such an onerous process for getting a ruling on the crime fraud exception that if you can find another way to break through, and if you look hard enough and if you're creative about it, frequently there are ways to break the privilege without pursuing crime fraud, because basically there's shifting evidentiary burdens, and the court has to look at each document. And with these types of cases, the fraud isn't the court might be looking for a piece of paper that says we're going to commit a fraud. That's not the way it works. It's the entire file is what creates the fraud. It's
right.
There's
a label on there that says fraud file.
Yeah, exactly. So it's proving the fraud is the complex part, and you're not going to prove it when they're going through a privilege log, reading one document after another. You need to put the whole picture together. But the bottom line is that if you're practicing in this area, you should be dedicating 25% of your time to fighting the privilege, whatever it is. That is the main battleground, because that is where the bodies are buried.
Let's switch topics, because we've got a couple others to go. Let's turn to ethical issues that we deal with, and I want to start with you, Metta, because I think the Bahamas has one of the biggest problems or restrictions and one of the biggest solutions. And I don't, as lawyers in my firm will tell you, we're not in the problem business. When they come and say we have a problem, I'm like, we don't do problems, we do solutions. So go away until you come with a solution. We're not in, we want solutions. So we hope everything we identify as a problem, we've got at least some solution.
Well, what?
How do we fund these cases? How do we deal with contingencies?
I thought you were actually referring, just following on from what Zachary was saying about, you know, evidence and fighting the privilege and so forth. In the Bahamas and in England, evidence which has been obtained illegally is not inadmissible. And that there was but there are issues of confidence, confidentiality. So, for example, for decades there was what was referred to as the Hildebrand rules, and it was basically the view of the court was, look, both the parties are supposed to fully disclose their assets, income, and so forth, all their resources. And it's a form of self-help for the wife to secure as much information as she can about the husband's income and assets, you know, in case he doesn't disclose. So there was never really an issue. It was allowed. Not so recently, we've had a case, is Immerman and Tenjri, where the wife's brothers and father secured a ton of material off the husband's computer. I mean, 7 big, thick volumes of it. And that case turned everything around so that basically they had to give most of it back. And the key there was that it was confidential material, and at the time that they took that material, the duty on the husband to comply had not been breached, with his full and frank disclosure had not been breached. So they weren't allowed to use it at that time. But further on down the line, you know, she would be able to rely on what she could remember, and she'd be able to use some of the documents. There's a discretion on the part of the court as to whether or not to allow them in, and they very likely would be allowed in, given the failure of the husband to comply with his obligations to the court in order for it to do its job, which is to divide the assets, and it needs to know what's there. So there's that aspect.
Well, let's stay with that. I was actually setting up a different ethical issue, but this is a very important one because it comes up. We've done 4 or 5 large, high net worth asset recovery cases in the matrimonial context, and every single one of them, there's evidence that the wife has obtained from somewhere where it ranges from outright criminality to just sort of, well, dodgy, okay, where it's close. We're not really sure.
Are you saying how she obtained
How she obtained it. So whether she went onto someone's computer, or she went onto a company computer, or she took photographs of something
Sure.
that were private or confidential. Let's assume for the moment that the information was obtained in a way that was violative of law, period. Whether it be Florida law or some other law. And you do have to think about where you're using your evidence, because if you come to the United States with the idea that illegally obtained evidence is easily usable, just like it's usable, and it's up to the judge whether he or she allows it in, that may not be the rule here in the United States. And so you may be then taking a very good case and making it a very bad case because you just didn't understand or take the time to learn what the local rule was. So let's assume that it's illegal. And look, I've yet to have one that doesn't have evidence in it that wasn't procured through some means that probably illegal or close to being illegal. Zach, how do you deal with that? I mean, you've heard Metta say that the English courts will look to the weight they give to it, although there seems to be this idea that if they haven't yet breached full and frank disclosure, you're going to have less latitude than you would after they breach full and frank disclosure? How is it dealt with in the States?
Well, it is a gray area under, when in these, particularly with information taken off of computers and other people's email accounts, in the context of the family. The legal standards can be somewhat forgiving if the evidence is that the wife and the husband shared passwords, and there was a computer, let's say in the living room with a saved password and things like that. It can be forgiving. However,
or if the kids used it for homework, stuff like that.
Yeah, so we have litigated that type of issue before successfully on behalf of the person who obtained the evidence. However, we put in our fee agreement that and when we discuss with our clients when they come in, we don't want anything like that from them. And we, despite having litigated it in the past, we avoid it like the plague, and we'll tell people, we don't want it, don't get it like that, stay away from it, because if you have that type of issue in your case, in the type of cases that we're talking about. So again, a normal divorce is entirely different, but in this type of case where you're trying to unwind a fraud, if you have that type of evidence, you're going to play into the two biggest defenses that the fraudster has. The first is the pox on both your houses strategy, which is, I'm not the only bad guy in this marriage. We're both bad. You shouldn't like either of us. Kick us out of your courtroom. She steals information from the computer. She broke the Computer Fraud and Abuse Act. She broke the Stored Communications Act. We got to litigate whether or not she should be penalized for it. It's a sideshow. So, as I said, the two strategies are: one, make your client look bad as well. You're trying to wear the white hat, and you don't want anything in your case that can take away from that. And the second thing is you're trying to get to the end. And if you can have a sideshow on how you obtained your evidence, you're going to be litigating that for 6 months or a year, in which time the assets are disappearing, they're being spent.
How expensive are those sideshows?
As expensive as the case itself. Because not only with that type of issue, you can have instances in which there's interlocutory appeals, because they can claim that there will be irreparable harm from the use of this evidence. And once you're going in on evidentiary hearings about how you obtain these emails and having appeals and so on, you're losing your case. And so we are very clear with our clients, and would terminate a client if they brought us that type of evidence, despite our clear directions not to.
Do you have the ability in the States to seek, with the wife's very strong suspicion that there's a ton of information on that
computer, you can get it the right way.
You can get a search and seize order so that the laptop is taken, a third-party officer of the court is assigned the responsibility of going through everything and sifting the privilege from the privileged material, and then reviewing it with the husband's lawyer and coming up with the balance, and then that go before the court?
You can. It's just one of these things that's extraordinarily difficult. So the entire case is about building the foundation for that type of relief. You come in and, you have to remember that in every case that the judges are hearing, particularly in the matrimonial field, where everybody says everybody is a terrible person, right? So you need to convince your judge that this is the extraordinary case where somebody really is a terrible person, and they need to enter the types of orders that are only entered on very rare occasions. So getting, an order where data is secured and investigated by a third party, you can get those, but you need to lay the foundation, and it takes a lot of work.
Well, let's stick with that for a minute, because I think the issue of how you deal with this evidence, and computers and email are more and more a very important part of what we do. In a case we had a client that came to us where the client, and we weren't involved in this part of it, but the lawyer who dealt with it had to deal with a minefield. And the minefield was as follows. there was a computer that was a company/computer and personal, both. She took it. She physically grabbed it at the time she filed for divorce or just before. What she did it, and she also went and copied it on a hard drive and put the hard drive in a safe. So lawyer had computer, and then lawyer knew client had hard drive in a safe. So the lawyer, I think rightfully, disclosed to the court that she had this computer, and there was a bona fide belief that there was information on there that was both that was relevant to the assets. That he was, of course, saying he was impecunious and he had nothing, and the business was doing very poorly, and she just doesn't understand business. And so what the court did was had every single thing on the computer printed out. It filled a quarter of this room, and had a person appointed in Palm Beach County to go through every single page and divide out business or personal, business, personal, business, personal. And half of it was business and half of it was personal. And so she got to look at all the personal stuff, and was an order that allowed us to look at the business stuff post-judgment. It was preserved for post-judgment so that if it turns out that she was able to get a judgment, then we can go after it. The difficult minefield was, and it never came up, but he was going to, if it came up in court, that if the court asked, or anyone asked in depot, that did you make a copy of this, he would have had to disclose, yeah, we have a copy of it. But it never actually came up. He was prepared to disclose it, but he waited for the question. That's a tough way to live, having that sort of Damocles hanging over your head as a lawyer, because a judge could easily say, well, I think you had an affirmative duty to disclose that to me. I'm not sure that's right. A lot of research went into that issue, or whether they did or they didn't. But the decision was made, and ultimately that information proved to be a treasure trove where the corporate assets were, and that the corporation, in fact, not only was doing very, very, very well, but it was purposely being masked by virtue of a series of internal transactions with other family-held corporations to suck the value out of it, so that it made it look like it was a company doing very poorly. So those are some of the issues we have to deal with. Another ethical issue I want to get on. Oh, John? Yeah, we're going to get to that. We're going to get to that. That's getting evidence, privilege issue, transfer of assets to children. We're going to get. Give us 1 minute to get to that.
So the question: at what point in the marriage do you typically see these collateral structures being fixed?
I think that's as unique as the marriage. It really changes. It depends. I mean, some people are paranoid from the beginning and always have this, or they're involved in a family business that has this in it as part of it, and sometimes it's done in anticipation of what they see as a slide in the marriage, or sometimes you could almost trace it exactly to when the mistress appeared. That's when this starts to happen. Right?
But it's very relevant, certainly in the Bahamas and in England, it's very relevant, because we have in our Matrimonial Causes Act, we have a section which provides for setting aside transactions which appear to the court to be designed to reduce the amount of assets that are available for distribution. So that timing is significant, and certainly, of course, from the moment that a divorce petition is filed, any transactions would be open to being set aside.
I would echo Metta's comment, which is the key word in your question is, when do you see in these marriages these fraudulent entities being set up? And I would say that if they're being set up from the outset of the marriage, it's very likely they're not fraudulent, because they're not being set up for the purpose of defrauding the wife or the husband, whatever the case may be. And so from my perspective, if it's not being set up at the end of the marriage, when there's a mistress or whatever the case may be, then in all likelihood, it is not something that is fraudulent. So you have to keep that in mind, that there's obviously legitimate asset planning that people can do, and the question is whether or not it's legitimate. And if it's not being done in anticipation of divorce, then your client is going to have a hard time convincing the court that it was transferred out of the parties' names to defraud her or him.
On that point, if the corporate structure is there from the beginning, it could very well be that whether wife knew or not, or spouse knew or not, that structure was there to park income offshore in a way that was perhaps violative of tax law. So you're now dealing with an estate that is tainted or is quote unquote dirty money. Have you guys seen that, and how does that impact the way you conduct these cases?
Well, before I answer that, I actually want to go back to the point we just made. So there's the fraudulent transfer aspect of it, but if there are entities that are set up earlier in the marriage, there might still be ways to get access to the assets and the entities as part of the marital estate. You still have basic alter ego doctrines where if you can show that, that let's say there's, as you said, some entity parked offshore with a lot of money in it or a lot of assets in it that one of the parties to the marriage uses as an alter ego, then you can bring that into the marital estate, whether or not it was set up to defraud the wife. I mean, if it's an alter ego, it's an alter ego. So anyway, but now
let's go to the next one.
The tax issue has been used certainly by wives to secure settlements successfully, and there's a number of cases in England that I'm aware of. But there have also been a number of cases where the husband has complied because he doesn't want the matter to be disclosed, but through the affidavit evidence, it's still come out and it's been referred to the tax authorities by the judge. So it's there, and some judges will refer it and some judges will not be interested. In the Bahamas, there's issues with regard to payments to do with businesses and so forth, which may be disclosed, but the court rarely follows through. The focus stays on the distribution of the assets between the parties.
But wouldn't that, I think that's one of those double-edged swords, right? Because husband can just as easily say, well, you may not have known, but you're still liable. The IRS could care less, and we have a very well-known IRS agent right here. They could care less about that. And so if we, if we want to go down that road, then you might get some money, but you're going to end up paying it, and you may have some criminal liability yourself, or at least some civil penalties, and so you're really not going to get all that you think you get. So I think that's one of those things that really requires you to sort of tiptoe through the minefield on both sides, no?
Well, I understand what you're saying. My partner happens to be a former AUSA and has a very, very strong view about these types of things, and obviously we consult with our clients, but typically if we see criminality, we report it, and the chips fall where they may.
Well, let's move on to another ethical issue, and that is, how do you pay for this? And you'd say, well, how is that an ethical issue? Because I know in Florida, and I think throughout the United States, you cannot have a contingency case in a matrimonial proceeding. You can have it in other cases, but you cannot have it in a matrimonial proceeding. I understand from my colleagues in the Bahamas that they're still yet at all. Although we're hopeful they're going to come around on that at some point in the Bahamas. But so how do we deal with? Let's start with the Bahamas, Metta. How do you deal with allowing a spouse, let's say the wife, who's essentially been rendered impecunious because husband has taken everything offshore and is willing to only give very small amounts? How do you deal with that when these cases take millions of dollars? I mean, you cannot really do these cases offshore where you have to hire forensic experts, investigators, and lawyers in various countries. You're looking at $2, $3, and $4 million in fees. Of course, if you tell them it's $2 to $3, $4 million in fees at the very beginning, the people faint. But it's really what it generally will get to. How do you deal with it?
Well, it's a very difficult situation. Before proceedings start, I would recommend to the financially dependent spouse that she finds ways to secure funds that she has access to. Two, she's entitled to maintenance pending suit. So once you file the divorce petition, you can apply for interim periodical payments or maintenance pending suit. And maintenance pending suit is assessed on the basis of reasonable needs and clearly a reasonable need is the need for funding so that the wife can avail herself of the same caliber of legal team and accountants to represent her and address her issues as the husband is able to. One of the, so in the context of that application, you would have to show the court that she doesn't have the ability, the capital of her own to pay legal fees, that she's been unable to secure any litigation funding or loan from the bank, and then the court would need a reasonable estimate of what her anticipated legal fees are and the nature and complexity of the issues involved. And that's where you tend to get, you tend to face some difficulties. You want to show the assets that are involved, and you want to show the difficulty that you're having with getting disclosure, or that there's been some disclosure already which is clearly, incorrect, and that this is going to be an uphill battle. But one of the problems you face is that the judges do not have the same perception of what is reasonable amount to spend on legal costs. And so you have to do things like, if you've had, for example, the husband's QuickBook accounts and he's put in, his accountant's put in what he's been paying in legal fees, and you can say, he already spent $100,000. In fact, he said that in an affidavit, to seeking to discharge the injunction that we got to preserve assets. So if he spent $100,000 on that, and actually we've been very reasonable, we only spent 20 to get it, that is indicative of the type of money that he's prepared to throw behind the case. The client got a letter, an email from him saying, I'm going to fight you, and da-da-da-da, and this will be a battle here and there, and I'm prepared to throw all the money that's necessary behind it. Here it is. She's got a big battle facing her, but it's still difficult to get the money that you need by that means.
Zach, I'd like you to cover how this is dealt with in the U.S., but I want to mention one point. It's virtually impossible to get a litigation funder to take one of these cases pre-judgment, because there's too many things that can happen. There are too many variables, including the possibility, albeit in some cases very low, of reconciliation. That was the word I was struggling for earlier. And what does the funder do? They've already put $1 million on the street, and there's reconciliation, and that's it. They're non-recourse. They can't get paid. So post-judgment, I think funders are very interested in this area. But pre-judgment, pre-equitable distribution judgment, I think it's virtually impossible.
Well, so the sad truth about this sort of situation is that in many instances this type of fraud works, because I'll talk about how temporary relief and availability of prejudgment fees and things like that. But the fact of the matter is that the potential litigation funders out there, it's really just it's law firms like mine that are well capitalized enough to carry cases without being paid regularly or possibly until the end. But the fact of the matter is that many of these cases, I'll say the women, but it can be either sex, but they go out and they look for lawyers, and in general, family law firms are small firms that, they're small businesses that they cannot carry large account receivables for a long period of time. And so when somebody comes into somebody's office and says, this is going to be the fight of your life to be able to recover anything, and it's going to take 50% of your time over the next 4 years, they're going to be turned down even by big family law offices, big successful family law offices, because it's just not practical for them to carry a case like that. And so, instances in which cases have come to us, it's not necessarily the case that we were their first call. they've gone to different law offices and they've been turned down, and they might say you should try Fisher, Bendeck, and Paton because they take on cases like this. But obviously we only take a few cases at a time, so when we turn them down, what happens is that people are settling their cases for pennies on the dollar because nobody will represent them, and they are taking, in the beginning, what I talked about is when the fraudster says, you'll take what I'll give you, that's what happens. And so these frauds can be and frequently are successful. So that's just kind of the sad truth of it. Now, in terms of the law in the state of Florida, there is something called temporary relief, and you can go in, just like you were saying, and ask the court to provide, the more moneyed spouse will provide fees to the less moneyed spouse. But the practical reality is that these cases that we're talking about are rare. That our family judges don't see many of them, and to the contrary, the average divorce that is coming before the judges, they're pro se divorces, or they're people who are fighting just to fight. And so the judges are loath to provide a war chest in a divorce. Now, if this were a business dispute between two partners, and you came in and said, this is a $500 million business dispute, and so it's going to cost $5 million or $10 million to litigate this dispute. Business people and judges might understand that, but when it's a divorce, there is an inherent sense that it shouldn't be that there's no way that could be justified in a divorce, even though it really could be. That the litigation will move the needle by far in excess of what is being spent on the litigation itself, that the merits really need to be addressed substantively with that kind of litigation. But the judges frequently, and understandably given their experience, are worried that whatever money is given is going to be consumed on the interpersonal disputes of the parties, and it's going to waste the court's time. And so the temporary relief awards tend to be very small and not something that anybody could count on to fund this type of case. So again, if you're a small family law office, somebody comes in and says, this happened to me, will you take the case on? You would never take it on believing that you are going to get a temporary relief award that would actually fund the litigation that was necessary.
Not to mention that this woman is also dealing with all of the other things in her life, her car payment, all the other things that getting the kids to school, paying for that school, and on top of then asking for $30,000 or $40,000 a month to pay for lawyers. And I think the problem is a lot of divorce judges come from divorce practice where they were doing the small divorces, and they're like, I never saw a fee like that in my life. How would I ever approve that? So it really becomes a difficult sell. I want to move on because we're going to run out of time. As we always do in these panels, because we could do a whole day on this area. The next one I want to talk about are third-party claims, because one of the things we have to face in this is that a truly diabolical, devious, and committed spouse can actually truly render their spouse impecunious and take everything offshore. I've seen it. I've actually seen at least 2 cases where almost everything was moved offshore. And so at that point, you have to figure out, how do you do this case? Are you going to rush the judgment and take what you can get and leave a back door where you can go? I know there's English law that says if there isn't full disclosure, you can always revisit the judgment and get the equitable distribution amended if you can prove it. But by getting to judgment, you can maybe unlock funding with a funder where you couldn't do that or through contingency fees where you couldn't do that pre-judgment. But there is another alternative, and that is thinking outside the box, thinking about going after the people that helped the I almost said fraudster, but the diabolical spouse, husband, and how do they assist them? And I'm going to just tell you one of our cases we dealt with by suing mom, brother, and sister-in-law, who absolutely helped strip out all the assets out of the corporation that was the fundamental asset of the marriage. And that well, husband never showed up, husband went offshore, husband played hardball. Those three couldn't get out of it. We had them ensnared with an action that was separate and apart from the divorce. And I know that, Zach, your firm has done a wonderful job with those concepts. Why don't you talk about how you use third-party claims, whether it's against lawyers, corporate formation agents, banks, or family members, to sort of level the playing field.
Yeah. Well, one kind of interesting thing with the family members that assist with the frauds, the brothers or the parents and so on, is that surprisingly, it's not infrequent that those people helping have recently or are going through their own divorces. And so what happens is, their disclosures in their cases contradict the disclosures in your case. And once again, people, they can be hung up on their own fraud. So, the family, if a family is doing this sort of thing, you can, talk to the wife of the brother, and she can rely on the affidavits in your case and vice versa, and then they both end up losing. I mean, if you're able to litigate this type of case at the level that it needs to be, it's often the case that the person who's committed a fraud ends up losing far more than they would have had they been honest from the beginning, because of the adverse inferences and the lies and so on. But I would say that bringing in third parties is both one of the most essential parts of litigating this type of case and one of the most difficult decisions, because, as I said before, the enemy of your victory is the sideshow. And third-party claims are one of the biggest potential avenues for sideshows that can consume all of your resources that are out there. So, you bring in family members, and all of a sudden you're litigating the jurisdictional issues again, and the discovery issues, and whether you're harassing them. And when you bring in the entities, let's say frequently there's just an endless number of shell entities in these cases, and they hire lawyers, and so now your hearings need to be coordinated with, instead of let's say 1 or 2 sets of lawyers, you need to coordinate your hearings with 6 sets of lawyers or 7 sets of lawyers, and all of their notices of unavailability, and they all want to speak at every hearing. And so your forward momentum is significantly impeded every time you bring in a third party. But again, it's frequently essential and one of the key avenues for winning, but it's not an easy choice in any instance.
We would possibly subpoena those third parties and cross-examine them, because on a lot of occasions it's quite amazing how simplistic people can be. I mean, they do so many things and they're hiding so much money, but when you get down to it, it's pretty basic, and it can be tripped up very, very easily. So many occasions you've got family members who are, directors of a company, or they're shareholders, and they know nothing about what's going on to do with the company. You can show that just by bringing them to court and cross-examining them, and they're just simply not prepared, and putting things to them. So that's a way you can address it, quite simply.
And people might lie in different places too. So let me just ask a quick poll. How many of you practice either as a lawyer or non-lawyer outside of the United States? Raise your hand. Okay, how many of you have used 28 U.S.C. 1782 to procure evidence in the United States for your proceeding in the foreign country? 1. This is it's the atomic bomb, okay? Use it. You can come here, and 28 U.S.C. 1782 is a statute. We've done seminars on this at this conference, actually, where you can obtain evidence in the United States for a proceeding in a foreign area that is either on foot or running or reasonably contemplated. So to the extent that you're trying to figure out if you've got a third-party claim in the United States because the people who assisted the spouse are in the States, or there's assets in the United States, we can launch discovery very simply, relatively inexpensively. Steve Baker's in the back. He's used it. He knows it is a very, very powerful tool. and it is not that expensive. So it's federal court, and it allows you to obtain pretty much any kind of evidence from any party for use in your proceeding.
Or any person.
Or any person.
Any person,
Or any,
right.
So, and think widely, not just bank account information, but all kinds of information, hospital information, anything that you need for your case.
Well,
So
we've got this similar, we've got the evidence proceedings in other jurisdictions to the Bahamas, and you can basically get everything you want, including, you know.
you mean like The Hague, using The Hague?
Well, this will be as a result of the Hague.
But I'm saying you don't need to do that.
This is an act of in our jurisdiction, internal, which allows the protagonist in the foreign proceedings to get evidence from people who are in the Bahamas, and they can be any number of, and so they can be examined. They have to produce documents. It can be used for the purpose of inspecting, photographing, preservation, custody, detention of property, taking samples, medical examinations of people, all sorts of things.
That's beyond matrimonial, right? It goes beyond,
yes,
it's any kind of case.
Yes, any type of, what it can't be used though is for a fishing expedition. So you do have to be clear as to, you know, the documents that you're seeking, and the questions that you ask have to be relevant to the issues.
I always say, Judge, it is a fishing expedition, but we're fishing in a barrel, so we're going to get them. But it is a very difficult situation when you're telling. And I've dealt with counsel offshore that say, yes, we can do discovery, but you need to know essentially what you're asking for. Well, how can we know what we don't know? To quote Donald Rumsfeld, it's very difficult. So it's you know, we know, or we have evidence that there's a bank account because we see this one wire transfer, but that's all we have.
Well, in that case that I was telling you guys about earlier, where the husband was lying on the committal proceedings, I not only called the Director of Immigration, I called the banker who did all his banking and cross-examined him by way of subpoena. And he was compelled to answer truthfully. So, similarly, you can do that type of thing under these proceedings.
So,
because you're being specific about this man's transactions, this man's accounts. So, what is difficult about knowing, you know, whether or not somebody has an account with your bank, and have you transferred funds?
Exactly.
And what value of funds have you transferred?
You have to think three-dimensionally, and so this issue of many lawyers, especially domestic lawyers that do, for example, divorce, which is inherently domestic, think, okay, the world ends at the border of the United States. And if in a big enough case where you have indicators of evidence offshore, there are ways to get that evidence offshore, and vice versa. If you're offshore, there are ways to get that evidence in the United States. One area that I think where this mindset is very dangerous is prenups and postnups. And we don't have much time. We have a couple minutes, so we're just going to hit it and open your minds to the issue and let you. But I will tell you this: we had a case once where we were brought in, and there was a postnup, and you read it as a postnup. It was a postnuptial agreement, and you read it as a non-matrimonial lawyer, and I thought, oh, we're dead. It's done. This case is over. And then we started thinking, and we thought, wait a minute, this was signed in Toronto, so we need to talk to Ontario Council. So we went to Ontario Council, and like 2 minutes into reading, they're like, this is a piece of garbage. This can't be enforced. We're like, okay, hallelujah. We're back in the game. We're back in business. But we have to think about if you are in a foreign country and you have a U.S.-based prenup or vice versa, you need to get professional advice from that. It seems obvious, but you'd be surprised how many people don't do it. They just take it as, well, or even the spouse might say, well, I signed it, I'm stuck with it, there's nothing I can do. Not necessarily. The law, in this particular case in Ontario, the law required there be full disclosure to the wife of everything, and that the wife have independent counsel before she signed it. The counsel was procured by the other side, paid by the husband, and when we asked him, we called him up and said, did you get independent advice, or did you do an independent investigation? He said, no, I wasn't paid for that. I just showed up at the signing. I was paid to show up at the signing, and she signed it. That was it. no, that's death. That was death. That prenup or postnup was actually thrown out. Obviously, this is its whole area, not my area, their area, prenups and postnups. I don't know if you want to just have a closing word on those, but all I'm saying is make sure you think cross-border before you accept something as done and dusted.
My only point on that would be that's the 1 in a million case. Most times when people come in and they want to talk about challenging their prenup, it's 20/20 hindsight. And as a general matter, we turn down those cases if they. And we've taken a couple of them and regretted it. I generally have a perspective that adults should be held to their word, and that we should be held to our contracts that we sign. And a lot of the law around this area also has a little bit of, I would say, inherent sexism in it. This kind of concept that, because it's almost always gendered in this way, the idea that somebody could get so excited about a wedding, and the evidence is always really incredibly sexist in this sense. It's the wedding dress was bought, the invitations had gone out, the wedding was big and exciting, and therefore somebody has lost the ability to rationally evaluate a contract. I find those arguments to be not appropriate, and so it's just not the type of case that we like to take on. We're more likely to defend an agreement than we would be to challenge it.
Well, I've had a case, and in England, the law used to be that, it could go either way, and it was entirely a matter of discretion. And then in 2008, 2010, we had Radmacher and Granatino, which really clarified the situation, made pre- and post-nuptial settlements far more likely to be adhered to, whether or not the party had legal advice. So long as they had an opportunity to take it, it's entirely up to them whether or not they took it, and the nature of that, the nature of the advice that they chose to take. So it doesn't matter that the other spouse paid for the lawyer. That's up to them. The key question that the court asks is, were they aware at the time of signing of the implications of signing that nuptial agreement? And looking at it now, in the round, is it fair in all the circumstances? So the court still retains a discretion, but it's definitely, you really tend to get them enforced unless there's significant issues. And in the case that a major case I did in the Bahamas, which was a US prenuptial agreement, in that case, just carrying on from what Zach was saying about, the wedding, and you're supposed to have prenup signed sort of like 3 months before, not 2 days before. In my case, it wasn't just signed 2 days before with the husband's lawyer, the husband getting a lawyer for her, and having no proper disclosure. She had also been told, when I last got married, we couldn't have children. I want to be sure you can have children before we get married. So then when she got pregnant, it then became, well, now I'd like us to have a prenup before we get married. And that was never negotiated. He just went back and forth with his lawyers. But even in those circumstances, our court really was strongly influenced by the terms of the prenup. Yes, she got more than probably about 7 times more than she would have got under the prenup, but not nearly as much as she would have got had there been no prenup.
To use a soccer term, we are in injury time right now, so I want to be careful. But the 2 things. One, we never got to John's question, and it's a very rich area to explore, which is children. There are the children, sometimes the issue is, who do I represent? Do I represent the children and the mother? Or do I represent, and some cases go on long enough that the children convert from minority to majority in the middle of the case. And now you have a whole new client. And that client may have an entirely different idea about how that case needs to run, and you may have an inherent conflict. And I'm just issue spotting now because we're not going to have time to do the discussion on this. The other thing is, children as a weapon. And you know, as a lawyer, you have to think about both the ethical, the professional, and the human aspects of children as fact gatherers. I mean, I had a case where one of the daughter decided that she was going to go visit her dad, and she took photographs when he was we went to the bathroom of his credit cards at dinner. So we now had his credit card information that we didn't have before. We didn't ask her to do that, but she did it, and I felt perfectly comfortable using that. And some people wouldn't. Some people might not feel comfortable. I did, because we were in a knockdown, drag-out battle with a scumbag, actually, to use a legal term. And so I felt we should use that. So John, I apologize that we're not going to be able to do this in a full way. I know there are other questions. The other panel is lining up, or some people perhaps, to get up here. So we're not going to be able to go into this, but we're all going to be around. We'll be around throughout the day to answer questions. Please help me and join me in thanking both Metta and Zach for this panel. Thank you.